received act of acceptance of the act dated on the 24th February 2016. That means that the agreement took place. Nevertheless, he denied payment without any exceptional circumstances. And to summarize all the mentioned above, we respectfully request the tribunal to issue an award that is mentioned in our request for leave. And the first one, we order the respondent to pay the claimant damages amounting of $11 million. B. Ordering the respondent to pay the claimant any interest accrued on the amount of damages stated in some paragraph A above. Point C. Ordering a posterior interest on the amount of damages claimed in subparagraph E above from the date of the award till the date of payment. And the point D. Ordering the respondent to pay the costs of this arbitration proceeding, including the costs of the arbitral tribunal, legal and other costs incurred by the claimant on a principle of full indemnity.
Thank you. Any questions? No? Then we can move on with the respondent.
Yeah, thank you very much. The main goal that I'm trying to achieve right now is to prove that the submission of documents under the letter of credit by the claimant was improper. As the claimant correctly stated, on the 7th of March, the claimant made a presentation under the letter of credit in order to obtain payment. The claimant presented the following documents. The claimant's invoice of the yacht, the certificate of quality of the yacht, the certificate of origin of the yacht, and the act of acceptance. Shortly after reviewing the documents, we found some discrepancies and notified the claimant. First of all, it is obvious that the act of acceptance is not signed by the buyer. The conclusion is confirmed by a simple comparison of the buyer's signature, Mr. Vasyl, on the act of acceptance, and the one on the contract. According to the Article 14D of the UCP 600, data in documents, when read in context with credit, the documents itself, and international standards banking practice, need to be identical, but must not conflict with data in that document and other stipulated documents of credit. But there is a contradiction, in our case, between the signature of Mr. Vasyl on the contract, on its banking card, on its business correspondence, and the one on the act of acceptance. The main instruction for a bank, while verifying whether the presented documents were proper or improper, is international standards of banking practice issued under the UCP 600. For checking letters of credit issued under the UCP 600, published by the ICC in 2013. According to Article A18 of ISBP 745, documents that are not transport, particularly the act of acceptance, it is not a transport document, must be made in compliance with the terms of the letter of credit. And if there are any under subsections F and D of the Article 14 of the UCP 600. This formal sign is a signature of a person according to paragraph A of the paragraph A20 of the ISBP 744. According to the materials of the case, the respondent analyzed the signature of the act by comparing it with the existing signature of the sole authorized representative of Ltd, Mr. Vasyl, and concluded that the signature was forged, as it can be clearly identified that the act was signed by Konstantin Zhivazovsky. That's how we interpreted the signature.
Can we see it?
Yes. May I have it? Well, you can compare. I'd like to draw your attention to page 28 of the case materials. And to page 19. On page 19 you can find the signature of Mr. Vasyl. Mr. Vasyl. On page 28 you can find the signature of Konstantin Zhivazovsky. Within the letter of credit, the respondent pays attention only to the documents and is not required to analyze the circumstances of the signing of the act the subsequent actions of the parties of the contract, and documents not specified in the letter of credit. There is no evidence in the case that Mr. Żywazowski is working for Manifestum Ltd and has a power of attorney. Mr. Evazov is the only one and sole representative that can sign legal documents, including acts of acceptance. Also, paragraph A27 of ISBP 745 involves the assessment of the evidence of the original signature. And this assessment was carried out, therefore we concluded that the act of acceptance was forged. Also, we would like...
Is it a forgery, or is it just somebody who signed a contract who didn't have any authority to represent the company?
Well, we don't know. We don't know that.
Well, forgery is, a criminal act,
well,
so that's a very serious allegation.
We just see that two signatures come into contradiction.
Okay, let's leave it at
We just see that these two signatures, which is enough for the refusal. Also, I'd like to draw your attention to page 20, where the documents required for presentation are listed. First of all, the claimant needed to present a statement in the form of Annex 1 signed by an authorized representative of beneficiary. But as you can see on page 24, the statement differs from Annex 1 on the letter of credit. An authorized copy of shipbuilding contract is also required, but no notary stamps are presented in the case. So that is also improper presentation. Also, invoice of the beneficiary, we don't have questions to this. Certificate of quality, certificate of origin, that's fine. The act of acceptance is also improper presented. National passenger ship safety required by letter of credit was not presented also. We would like to draw your attention that there are 4 discrepancies between the documents presented by the claimant, and therefore the presentation was improper. And that's why we refused to pay. So, on the basis of the above, respondent respectfully requests the arbitral tribunal to find that it lacks jurisdiction over claims submitted by the claimant, the ICC Court of International Arbitration to suspend the proceeding until the award of the ICC case number 1998, the arbitral tribunal, once it is constituted, to suspend the proceedings until the award of the case 1998, the arbitral tribunal reject all claims of the claimant. Also because in the claimant's memoranda, there is no monetary evaluation of some claims. Due to the subparagraph D of paragraph 3 of Article 4 of ICC Rules of Arbitration, money evaluation is required for everything. And also the arbitral tribunal, in order to order the claimant to reimburse the respondent all costs related to this arbitration. Thank you for your attention. That would be all.
Thank you. Do we have questions? Not from you? Not from you? Okay. But we have a rebuttal, I understand.
Can you start?
Yep, please.
So we told that bank, the data in the documents, one unwritten context with the credit, the documents itself and international standard banking practice need to identical to, must not conflict with data in the documents and other stipulated documents on the credit. It's according to the Article 14 of UCP 600. And according to the UCP 600, Article 17, point B, a bank shall treat as an original any document bearing an apparently original signature, mark, stamp, or label of the issuer of the document, unless the document itself indicates that it is not an original. So, according to the point B of Article 17, we can submit that bank should take the signature as original and not go into the dispute. According to the money evaluation, it is two practices of money evaluation into in the arbitral tribunal. We can make the money calculation by ourselves. It's one type, and the second type it can be made by arbitral tribunal. So we made according to the second step, and we will believe that arbitral tribunal will make proper money evaluation of the case.
Thank you. Maybe just one question. So you're saying that as long as any, handwritten signs are on the document, that qualifies as a signature? I'm talking about the argument that counsel for respondent made regarding the, wrong signature below the document on page 28.
Yeah, a bank shall treat this as an original signature. If it's not if it's not indicates itself that it's not an original.
Do you have any authority saying that you only need, something on the letter of credit which doesn't have to resemble the name that's printed below?
If they want to say that this signature is not appropriate, it is not in their competence of the bank. It should be made by special authorized authority, but not by the bank. If they wanted to do this, they should apply to the special authority, because they have lack of authority in this country.
Okay, thank you. And sorry, Vasyl?
Yes, you mentioned that you mentioned UCP Article 17, but case materials show that you presented a copy of an act of acceptance, but not the original one. That's my first point. And second one, you claim that we do not have authority to judge whether the stamp is original or not, but you want us to have the authority to claim whether the signature is original or not. That's a little bit contrary.
That's it, right?
Yes.
Great, thank you. Okay, so I would now like to ask the parties whether there's anything that you would like to complain about how we have conducted the arbitration. No? Okay, good. Then I would hereby like to close the proceeding, and we would ask everybody to leave the room for a little bit, and we will deliberate, and then we'll give you some feedback about your performance. Thank you.
This video camera, is it switched on?
Yes, it is.
Maybe just take it with you.
Yeah, take it with you.
Fine.
No,